Welcome back to America's Fractured Politics. On the night of September 2nd, a small boat in the Caribbean was hit by a U.S. missile. The vessel was suspected of carrying drugs. The first strike blew the boat apart and killed most of the people on board, but not everyone died. At least 2 survivors were left alive, clinging to the wreckage in the water. They were wounded, shipwrecked, and no longer a threat to anyone. And that's when, according to multiple reports, a second strike was ordered. Not to disable the boat, not to stop an ongoing attack, to kill the survivors. What does the law say about that? What happens legally when a government decides that leaving no witnesses is a tactic, not a crime? And if the reporting is accurate, who can actually be prosecuted for what many experts are already calling a textbook war crime? You've probably heard at least pieces of this story by now. Multiple major outlets have reported that U.S. forces operating under the Trump administration's expanded campaign against so-called narco-terrorists at sea, first destroyed a vessel believed to be drug-laden, killing most of the 11 people on board. Then, after confirming there were survivors in the water, a special operations commander allegedly ordered a follow-up strike that killed the remaining survivors and sank what was left of the wreck. Since those stories broke, current and former military lawyers, judge advocates, or JAGs, have been very clear. If those facts are even roughly accurate, the legal problem is not solved. Ordering or carrying out an attack on clearly incapacitated, shipwrecked survivors is one of the clearest violations in the entire law of armed conflict. In this episode, we're going to unpack that in 4 big steps. What happened, as far as we can tell, on and after September 2nd? How international humanitarian law treats shipwrecked survivors and people out of the fight? What charges this conduct could trigger under international law and U.S. law, including the War Crimes Act? And finally, who could be on the hook, legally and politically, from the operator who fired the weapon all the way up the chain of command? Let's start with the facts we actually have. First, a quick timeline. On September 2nd, U.S. military assets operating in the Caribbean engaged a small vessel that intelligence officials had tagged as a suspected drug smuggling boat. This was part of a broader series of strikes the Trump administration has been conducting against alleged drug boats in the region, framed publicly as a way to choke off narcotic flows and put pressure on the Venezuelan government. According to detailed reporting, a U.S. aircraft launched a precision strike, think a guided munition, against the boat. The first strike appears to have been militarily effective in a blunt sense. The vessel was destroyed, most of the people on board were killed, and debris was left floating on the surface. So far, that's already controversial, but it fits within the pattern we've seen. Use military force against small unflagged vessels suspected of carrying drugs, often far from any declared theory of war. Where this incident becomes legally explosive is what allegedly happened next. According to sources who spoke to reporters and to Congress, surveillance feeds and battle damage assessments showed at least 2 survivors in the water after the first strike. These were not people firing weapons or maneuvering a boat. They were in the water, hanging onto wreckage, wounded, and plainly no longer in any position to attack anyone. Multiple stories describe conversations among commanders about the survivors. One narrative that's emerged, a special operations commander overseeing the mission authorized or even requested a second strike with the specific objective of eliminating the remaining survivors. In other words, the decision was not, do we rescue them or do we capture them? The decision was, do we kill them? At the political level, there's reporting that the broader campaign was being driven by a very aggressive directive from Defense Secretary Pete Hegseth, summarized by some officials as a kill-them-all posture toward people aboard these alleged drug boats. Members of Congress who have been briefed or half-briefed on the incident are now openly using the phrase war crime in public interviews and calling for investigations and hearings. That's the factual skeleton. Initial strike, survivors in the water, deliberate follow-up strike to kill those survivors, and a policy climate that seems designed to encourage, or at a minimum, excuse such decisions. Now the question is, how does the law see that chain of events? To understand why experts reacted so fast and so strongly, we need to talk about one core concept in the law of armed conflict: hors de combat. Hors de combat is French for out of the fight. In legal terms, it covers people who are no longer participating in hostilities because they are wounded, shipwrecked, unconscious, detained, or otherwise incapacitated. Once a person falls into that category, they are protected. They cannot be deliberately attacked. They must be spared and refusable, collected, and cared for. This principle runs straight through the four Geneva Conventions and the customary rules that have grown up around them. On land, it applies to wounded soldiers who drop their weapons, to detainees, to medics, and to civilians who have taken no part in fighting. At sea, it has a specific expression in the Second Geneva Convention, which deals with the wounded, sick, and shipwrecked members of armed forces at sea. Crucially, the maritime rules don't only protect people on intact warships. They explicitly address shipwrecked persons, people in the water, on rafts, or clinging to debris, who are no longer resisting. These people are not targets. The Second Geneva Convention and its commentaries emphasize two linked obligations once a ship has been disabled and its occupants are in the water. First, attackers must stop treating those individuals as lawful targets once they are clearly hors de combat. Second, parties to the conflict must, as circumstances permit, search for, collect, and care for the wounded and shipwrecked without adverse distinction. That language, search for and collect, is a legal opposite of finish them off. And it's important to underline something that non-lawyers often miss. None of these protections vanish because you suspect the people in the water are bad guys. Even if every single person on that boat were a hardened combatant or a high-value cartel member, the law does not say, if they're bad enough, you can just shoot them in the water. Once they are shipwrecked and are no longer able to fight, they are protected. That's why when the story broke that an American commander allegedly ordered a second strike aimed at people floating in the water, former JAGs did not hedge. They described it as a paradigmatic violation of the protections for shipwrecked survivors and a likely grave breach of the Geneva Conventions, the treaty term for the most serious war crimes. But there's an antecedent question we have to deal with. Do the Geneva Conventions and the laws of war even apply to this kind of operation? Some defenders of these strikes have tried to argue that this isn't really a war situation. Their logic goes something like this. The United States isn't at war with Venezuela. The target was a drug boat, not a military vessel. Therefore, the laws of war don't apply. And if they don't apply, maybe the war crime label is misplaced. That argument misunderstands how international humanitarian law actually works. Legally, the full Geneva Conventions apply in two main scenarios: an international armed conflict between states and a non-international armed conflict where a state is fighting an organized armed group with a certain level of intensity and structure. Over the last 2 decades, the United States has stretched the non-international armed conflict category to cover transnational operations against non-state actors labeled terrorists or narco-terrorists. The Trump administration appears to be doing something similar in the Caribbean, framing these boat strikes as part of an armed conflict against organized narcotics networks, linked in their telling to hostile regimes. Many international lawyers are skeptical of that framing. Drug trafficking organizations are criminal networks. They are not by default parties to an armed conflict under the law. But for purposes of analyzing this September 2nd incident, it actually doesn't save the decision makers either way. Here's the fork in the road. If you accept the administration's narrative that these boat strikes are part of an armed conflict, then the law of armed conflict clearly applies, and with it, the protections for shipwreck survivors and the prohibitions on attacking people hors de combat. If you reject that narrative and say, no, this is not war, this is law enforcement or counter-narcotics, then the applicable body of law is international human rights law and ordinary criminal law, especially the right to life and prohibitions on arbitrary killing. On both branches, deliberately killing wounded, shipwrecked survivors who pose no ongoing threat is illegal under an armed conflict theory. It's a war crime under a law enforcement theory. It's an extrajudicial execution, an unlawful killing, potentially chargeable as murder under domestic law, and as a violation of the right to life under international human rights treaties. So the argument this wasn't really a war doesn't rescue the decision. It just changes the label on the crime. Let's assume for a moment that the U.S. position that it's engaged in some form of armed conflict with these alleged narco-terrorist networks is accepted. Under that assumption, what are the precise war crimes that an attack on shipwrecked survivors would implicate? First is the general prohibition on violence to life and person. particularly murder of persons taking no active part in the hostilities. That language appears in the Common Article on Grave Breaches and the Geneva Conventions and is reflected in the statutes of international criminal tribunals and the International Criminal Court. More specifically, customary international law, international humanitarian law, and tribunal case law treat it as a war crime to intentionally direct attacks against persons hors de combat, that is, against the wounded, the sick, shipwrecked survivors, detainees, or anyone who has clearly expressed an intention to surrender. The conditions for hors de combat status are straightforward. The person is in the power of an adverse party, or the person is defenseless because of unconsciousness, shipwreck, wounds, or sickness, and the person abstains from any hostile act. People floating in the water after their boat has been destroyed plainly fit this description. They have no vessel, no cover, no practical way to continue fighting. They are in every sense defenseless. If, as reported, commanders knew they were dealing with survivors in the water, and if the purpose of the second strike was to kill those survivors rather than to neutralize the ongoing threat, that mental state, intentional knowing targeting of hors de combat individuals, satisfies the core elements of a war crime. Second, there is the positive obligation to search for and collect the wounded and shipwrecked after an engagement, whenever circumstances permit. That obligation doesn't mean commanders have to commit suicide to conduct a rescue, but in a scenario where U.S. forces already control the airspace and have helicopters and ships in the vicinity, the argument that circumstances prevented rescue is hard to sustain, especially when in a later October strike, the same campaign did in fact rescue and repatriate surviving occupants from another vessel. Choosing to fire on survivors instead of attempting rescue is not just a failure to comply with a positive duty. It actively reverses it. Instead of moving toward the wounded to render aid, you move toward them with another missile. Third, there's the prohibition on no quarter orders that there should be no survivors. International law has long treated issuing an order that no quarter be given or that no survivors be left as a serious violation. Historically, that language applied to battlefields where one side announced in effect, "We will take no prisoners, we will kill everyone." If the allegations that senior officials encouraged or authorized a kill-them-all approach to these boat strikes are substantiated, that begins to look very much like a no-quarter policy at sea. Combined with an actual follow-up strike on known survivors, it goes from rhetoric to evidence. Put all of this together, and you have a cluster of potential war crimes. Murder of persons hors de combat, attacking the wounded and shipwrecked, failing to care for the wounded and shipwrecked, possibly issuing or implementing a no-quarter order. That's the international law side. But what about U.S. domestic law? The United States has a statute called the War Crimes Act. In its current form, it makes it a federal crime for U.S. nationals or members of the armed forces to commit certain grave breaches of the Geneva Conventions or serious violations of Common Article 3, including murder of persons not taking part in hostilities. In plain English, if a U.S. service member or anyone under U.S. jurisdiction intentionally kills people or hors de combat in the context of an armed conflict, that can be prosecuted as a war crime in U.S. federal court. The elements track what we just discussed. There must be an armed conflict. The victims must be protected persons. Here, shipwrecked, wounded survivors. The perpetrator must intentionally cause their death, knowing their protected status. If a prosecutor could show that the commander who ordered the second strike knew there were survivors in the water and nonetheless authorized the attack to kill them, that commander fits squarely within the statute's reach. And the War Crimes Act doesn't stop at the person who physically presses the button. It also reaches those who order, aid, or abet the crime. And U.S. law more broadly recognizes theories of liability for superiors who knew or should have known about crimes by subordinates and failed to prevent or punish them. Beyond the War Crimes Act, there are other potential hooks. The Uniform Court of Military Justice criminalizes murder, manslaughter, dereliction of duty, and violations of the law of war. Military personnel could be prosecuted in courts martial for unlawfully killing protected persons or for executing manifestly unlawful orders. General federal criminal statutes against murder could apply, especially if a court or Congress refused to accept the administration's armed conflict framing. And overlaying all of this is the U.S. constitutional requirement that the use of force abroad comply with congressional authorizations and with the president's obligation to take care that the laws be faithfully executed. Congressional critics are already warning that the September 2nd strike, and especially the follow-up attack on survivors, exceeded any plausible authorization for the use of military force or counter-narcotics operations. So on paper, U.S. law has plenty of tools to treat the killing of shipwreck survivors as the crime that it is. The harder question is political. Will they actually be used? Let's talk about who can be responsible. Start at the bottom and work upward. At the operational level, there is the air crew or weapons operator who actually executed the second strike. Under the law of armed conflict, service members have a duty to refuse manifest unlawful orders. And in order to fire on clearly wounded shipwreck survivors, people in the water, clearly out of the fight, sits firmly in that category. If an operator understood that this was the situation and fired anyway, they could face liability. But in practice, legal and moral responsibility tends to focus on the commanders and policymakers who create the environment and issue the orders. Next rung up is the Special Operations Commander, reported to have overseen the mission and allegedly authorized the second strike. If that individual knew there were survivors and directed the strike with the aim of killing them, that is direct personal responsibility for a war crime, both in international law and under the U.S. War Crimes Act. From there, responsibility can extend upward in two ways. Direct, if senior officials up to and including the Secretary of Defense expressly conveyed or approved the no survivors policy. That can constitute ordering or instigating war crimes. Reports of Pete Hegseth encouraged the kill them all posture, and briefings on these operations will be central to any serious investigation. Command responsibility. Even if a secretary or senior commander did not sign off on specific targets, they can be held liable if they knew or should have known that subordinates were committing war crimes and failed to prevent them or to punish the perpetrators. At the very top is the president. As commander-in-chief, Donald Trump is unlikely to be the person who drafted a specific target package for a given boat. But if the overall strategy, rhetoric, and rules of engagement he signed off on contributed to a climate where killing survivors was seen as acceptable or even desirable, he becomes part of the story. Legally, proving criminal responsibility at the top political level is always hard. It requires tying vague rhetoric and broad policies to specific decisions on the ground. Politically, however, Congress has less of a burden. It can investigate subpoena documents and witnesses and legislative constraints based on a pattern of conduct without proving a criminal case beyond a reasonable doubt. That's exactly what some lawmakers are now signaling. Senators like Tim Kaine have spoken publicly about reintroducing war powers resolutions and demanding full access to the legal justifications for these strikes, especially the alleged follow-up attack on survivors. Now let's go back to the other fork in the road. What if this isn't an armed conflict in the legal sense? From a human rights and criminal law perspective, the picture may be even worse. Human rights law, especially the right to life, applies at all times, war or peace. International bodies in many states take the position that when a country exercises control over individuals outside its territory, such as by detaining or targeting them, it still has human rights obligations. Those include the obligations to refrain from arbitrary deprivation of life and to investigate credible allegations of unlawful killing. In a law enforcement model, lethal force is supposed to be a last resort. You may only kill if it's strictly necessary to protect life from an imminent threat and if no less lethal alternative is available. That is a much tighter standard than the targeting rules in an armed conflict. Apply that standard to our scenario. Whatever one thinks of the initial strike on the suspected drug boat, once the vessel was destroyed and the remaining occupants were in the water, the imminent threat was over. At that point, under a human rights framework, the only lawful use of force against them would be to prevent a real, concrete, immediate threat to someone's life, not to prevent future drug trafficking or to deny a cartel a few operatives. Ordering a second strike to kill wounded survivors in the water, in that framework, is an extrajudicial execution, an intentional, premeditated killing by state agents without trial or necessity. That's a violation of the right to life under instruments like the International Covenant on Civil and Political Rights, and domestically it looks a lot like plain old homicide. This is one of those rare situations where the law is actually clearer than the politics. The body of law you apply may change the doctrinal labels, but it doesn't change the core reality. People who are no longer a threat were deliberately killed instead of being rescued or detained. In mid-October, the U.S. again struck a suspected drug-carrying vessel, as mentioned before, a semi-submersible narco sub in the Caribbean. That attack also left at least 2 survivors in the water. This time, U.S. helicopters rescued them and brought them aboard a U.S. Navy ship. They received medical treatment and were eventually transferred for repatriation to Colombia and Ecuador, rather than being detained indefinitely or killed. Whatever else can be said about the legality of the campaign as a whole, that October incident looks much more like what the law expects: disable the vessel, stop the immediate threat, then rescue and process survivors through legal channels. The difference between October and September is not the law, it's the decision. In October, somebody in the chain of command chose the rescue and repatriate option. In September, according to the reporting, somebody chose kill the survivors. The law has names for those 2 choices. One is compliance with the duty to care for the shipwrecked. The other is a serious international crime. So what happens now? As of the latest reports, members of Congress from both parties are demanding more information on who authorized the second strike and what the rules of engagement were. Hearings are being floated. Some lawmakers are talking about reviving or strengthening war powers resolutions to claw back authority over these kinds of operations. Former JAGs have published statements warning that failing to investigate, if necessary, prosecute would not just be morally wrong, it would erode the credibility of U.S. commitments to the laws of war and put American service members at risk of reciprocal abuse. If the U.S. publicly tolerates killing shipwrecked survivors, it weakens its ability to object when others do the same to Americans. Internationally, there is already diplomatic friction. Countries whose nationals were killed or targeted in these strikes, including Colombia, Ecuador, and Venezuela, are demanding explanations and in some cases suggesting their citizens were civilians or fishermen, not narcotics traffickers. That raises the stakes further. It's one thing to unlawfully kill combatants. It's another to unlawfully kill foreign civilians on the high seas. At the same time, the political incentives in Washington run the other way. No administration wants to see its own cabinet officials or senior commanders prosecuted. The instinct is always to narrow the facts, redefine the legal framework, and quietly close the file. That's where public pressure comes in. The reason this incident is getting serious attention is not because the law suddenly changed, but because journalists, survivors' families, and a few members of Congress are refusing to let it disappear into classified briefings and legal memos. Stepping back, why does this one small boat in the Caribbean matter so much? On its face, this is a story about 11 people on a vessel that, if you accept official claims, was part of a narcotics network. But legally, it's about something much larger. Whether the most basic constraints on wartime violence, constraints that say you cannot shoot the wounded, that you cannot execute shipwrecked survivors, still mean anything when the targets are unpopular and the operations are remote. The law of armed conflict was built partly in response to exactly this kind of abuse, the temptation to finish off the enemy rather than accept their surrender or rescue their wounded. That's why the rules on hors de combat shipwrecked survivors are so stark and why they feature so prominently in war crimes prosecutions. In the September 2nd case, the allegations are painfully simple. There was a boat. It was destroyed. There were survivors in the water. And instead of rescuing them, someone chose to kill them. If that's what happened, then this isn't a gray area in the law. It is the brightest red line the law is written to prevent. The harder part now isn't figuring out whether that line was crossed. It's deciding whether a government that crossed it is still willing to hold itself to account. If you found this breakdown useful, share it, especially with people who think discussions of war crimes are always abstract. Here the law is focused on something brutally concrete. Whether we, as a country, are willing to kill people who are already drowning. Thanks for listening.